Good afternoon, everyone, and welcome to our webinar on major changes and trends in employment and labor legislation across Ontario, Quebec, and British Columbia. My name is Genevieve Canton. I am located in our London, Ontario office, and I'll be kicking things off today by introducing the key topics we'll be covering. Over the next 37 minutes, we'll be exploring recent legislative changes that are shaping the workplace in these three provinces, including new employment standards, updates to workplace protections, and important compliance considerations for employers. We'll also discuss practical implications and takeaways that you can apply in your organizations. I'll be joined by my colleagues Matthew Ray, who's located in our Vancouver office, and Sophie Wabi Garcia, who's located in our Montreal office. And together we will aim to give you a clear understanding of what's changing or what has recently changed, why it matters, and how to prepare effectively. Before we get into today's content, a few housekeeping matters to go over. You've all been placed on mute. Please don't take offense to that, but there's a large number of you, so that was the easiest way forward from our perspective. There is a Q&A chat that's open. You'll find it at the top right corner of the screen, so please feel free to send any questions at any time. We'll do our best to answer them throughout the session, but it may be best to, we might have to deal with them by email afterwards if we run out of time. If you do need tech support at any point in time, there is a help button below the video window right next to the return to agenda button. And last but not least, the presentation is obviously for informational purposes only, and it does not constitute legal advice. So please do get in contact with one of our lawyers for guidance based on your specific situation. And with that, let's dive in and start by looking at some of the most significant legislative developments over the past year. And I'm going to turn things over to Sophie to kick things off in Quebec.
Thank you so much, Genevieve. So yes, as it was said, I'm going to go over key developments in legislation in Quebec. I'll go over, it's a lot of things to talk about, but I'll try to be as complete and brief as possible. We'll go over Bill 101, which was first introduced in April of this year, 2025. Then we'll talk about the latest provisions from Bill 96 on the French language requirements that came into force in June 2025. And I'll go over some notable recent upcoming changes, as well as general tendencies of what we can expect to come in Quebec. So we can move to the next slide. So first, Bill 101, as I was saying, was first introduced on April 24th, 2025 of this year. It's basically an omnibus bill that proposes amendments to different labor and employment laws in Quebec. And it aims really at creating a cohesive and a uniform legal regime in labor law and employment law. And basically the main changes, I would say, the main focus is on the labor code and on its arbitration process. So I'll talk about this on the next slide. Can we move to the next slide, please? Yeah, perfect. So as I was saying, the major changes really focus on the labor code, and the objective of Bill 101 would be to ensure the timeliness and the efficiency of the arbitration process here in Quebec. I'm going to go over the main modifications to the arbitration process. So first of all, there would be, if Bill 101 passes, a limited time period to designate an arbitrator. So once a grievance is filed, there's a 6-month limit to appoint an arbitrator, and if it's not the case, the party who filed the original grievance will have 10 days to ask the Minister of Labor to do so. Otherwise, if the party fails to do so, then the grievance will be considered as withdrawn. There would also be a 1-year maximum between the filing of the grievance and the first hearing, and this time period can only be extended once at the arbitrator's sole discretion. Bill 101 also introduces an obligation to consider mediation prior to the first hearing. You'll see that that's a common denominator within Bill 101. And it also grants the arbitrator more rights to require a preparatory meeting with the parties in order, for instance, to go over a witnesses list and also to just talk about the issues that will be discussed during the hearing. And another common denominator, or something that's really present in Bill 101, is the increase in fines. So there's I would say, a dramatic increase in fines in Bill 101 when it comes to the labor code, mostly on the obligation to negotiate in good faith and the replacement workers provisions. So that is for the main changes when it comes to the labor code. Can we go on to the next slide, please? So now when it comes to the act respecting labor standards, there are fewer changes, or there would be fewer changes in Bill 101. The most important ones are the creation of 2 new unpaid protected leave. The first one would be a leave that is not limited in terms of days, and it would allow employees to benefit from an unpaid leave in compliance with an order, a direction, or a decision under the Public Health Act, the Quarantine Act, or the Emergencies Act. So we can see that COVID-19 still has its effect on Quebec legislation. It also creates a new regime when it comes to leave for Canadian Armed Force reservists. And finally, again, as I was saying, an increase in fines once again. So I just added one example when it comes to violation of provisions regarding psychological harassment. Now they would go up to $50,000. And the fines could be also tripled or doubled in case of repeated offenses. We can go to the next slide. Now, when it comes to the act respecting industrial accidents and occupational diseases, so if Bill 101 is passed, it would create a new definition of worker, and essentially would, I would say, rather extends this definition to include executive officers. So that would be a first, but in certain circumstances only. So it would include executive officers who perform work for a person other than the person for whom they hold the status of executive officer. So that's kind of a mouthful, but that would be still a new extension of the definition of worker. And again, the introduction of a new amicable resolution process at the administrative review stage before the administrative labor tribunal. We can go to the next slide. When it comes to the act respecting occupational health and safety, fewer changes, but the creation of a new financial support for employers when it comes to a reassigned pregnant or breastfeeding worker. And finally, when it comes to the act to modernize the occupational health and safety regime, it would introduce a deadline extension to implement the prevention program and the action plan. The current deadline is October 6th, 2025, so it's just in a couple of days. So it would extend this deadline to a year, so October 6th, 2026. So we can go over to the next slide. Just to wrap up on Bill 101, by the way, so I just wanted to highlight the fact that it still remains under review at the moment. So its content still may change, so we'll have to keep taking a look on this. When it comes to the act respecting French, the official and common language of Quebec, as many of you may know, it was first introduced in 2022, but the final provisions came into force just a couple of months ago. And basically what changes now is that businesses with 25 or more workers for a period of 6 months must register with the Office québécois de la langue française. And within 3 months after receiving their certificate of registration, they would have to analyze the linguistic situation within their business. And essentially, if French is not generally used, then the Francization program must be implemented. And if French is generally used, then the office will issue a certificate. Still, the employers have to make sure that they keep up with their obligations. So there's an obligation to send a report to the office every 3 years. We can go over to the next slide, please. So we'll go over quickly on this, as I believe many of you may know. Bill 42 and Bill 68 came into force just a year and a couple of months ago, and it changes the legal framework when it comes to access to medical records in Quebec. So essentially, Bill 42 introduces a restriction of direct access to medical records. Now it's only a medical professional designated by the employer can have access to the CNESST medical record of an employee. And there are also increased fines in case of a violation of those obligations. And when it comes to Bill 68, I know because it's a recurrent question from clients. There is now a prohibition to request documentation for the first 3 absences of 3 consecutive days or fewer within a 12-month period. But it also introduces a prohibition to request a medical certificate for certain family-related leaves, specifically when it comes to the care of a child or the obligation of an employee as a caregiver. We can move on to the next slide. I mentioned it quickly when it comes to the Act to modernize the occupational health and safety regime. The last provisions will come into force in a couple of days, so October 6, 2025. And essentially, it creates obligations on all employers with a difference for employers who employ 20 workers or more and those who employ 19 workers or less, but both have to implement some kind of a health and safety program within their business. So it can be a prevention program, which is a more thorough, lengthy type of program, or an action plan. And so this will come into effect in just a couple of days, unless there's something that's happening with Bill 101, but I think we're maybe a little past that. So I'm not going to go too much into detail on this, but if you have questions, of course, feel free to send it to us. And we can go to the next slide. And just a few words on potential and upcoming changes. So maybe some of you know that Bill 89, will come into effect on November 30th, 2025, and it deals with essentially essential services within the province. And also there is another bill that's being presented right now at the Assemblée nationale, which relates to the regulation of telework or working from a distance. It has been introduced by the opposition, so we don't really know if it's going to be implemented, but at least we can say that there's going to be a debate around this specific issue in Quebec. So on this, we'll pass the mic on to Genevieve. Thank you.
Of course, I was on mute. Thank you very much, Sophie. So let's turn to some key employment law developments in Ontario. If you perfect, thank you. So the plan today, we obviously don't have a lot of time, so it's going to be a pretty high-level overview of some proposed changes to workplace laws coming out of Bill 30, the Working for Workers 7 Act. And from there, I'm going to highlight the most recent changes or upcoming changes to the ESA that many of our clients have been asking about. And then at the last second, I'm just going to give you a quick reminder on the minimum wage increase that's creeping up next week. So jumping to our first topic, which is on the next slide. Thank you. So as part of the ongoing Working for Workers initiative, the province has put forward some pretty significant changes to workplace laws. These touch on the ESA, the Occupational Health and Safety Act, and the Workplace Safety and Insurance Act. If we turn our attention to the next slide, I'll go through the changes to the ESA. Thank you. So the bill proposes the creation of a new unpaid leave specifically for group or mass terminations dubbed the job-seeking leave. The intention here is really to give employees who receive notice of termination in a mass termination scenario time to search for work, time to attend interviews, participate in training. If passed, these employees would be entitled to up to 3 days of unpaid leave if they receive a group notice of termination. In that scenario, employers would be able to request reasonable evidence from employees who elect to participate in this unpaid leave or take advantage of it. And the partial days taken by the employee would count as full days. Bill 30 also proposes to extend the ESA's current temporary layoff scheme. Specifically, it would allow for layoffs of 35 or more weeks in a period of 52 consecutive weeks, so long as the layoff is less than 52 weeks in any period of 78 consecutive weeks. There are some ground rules, however. The first is that the employer and the employee actually have to enter into an agreement with respect to the extended layoff. The employer needs to recall the employee within the time set out in that agreement. and employers need to seek approval and receive approval from in relation to the extended layoff from the Director of Employment Standards. Now, moving on to the next slide are the notable amendments to the Occupational Health and Safety Act. Thank you. I'm going to skip over the first point here because it's really not all that interesting, although a small win for employers. But the more significant change here is the bill actually proposes a new administrative monetary penalty scheme under the Occupational Health and Safety Act. Currently, employers might be exposed to penalties only after a charge for breach of the legislation and subsequent conviction. But if this change is adopted, inspectors would actually gain the power to impose monetary penalties without laying charges or going through a conviction process. This is quite a significant development, and in practical terms, it feels stricter because penalties could be applied obviously much more quickly. But the clear policy aim here is to encourage employers' compliance through immediate financial consequences. Now, the last point to make about this is that the bill itself is silent on the amount of the administrative penalties, but it does note that this would be determined by further regulations. Now, up next, on the next slide is, yes, thank you. So Ontario has also proposed some important updates to the Workplace Safety and Insurance Act compliance and enforcement that, if adopted, would raise the stake for employers, so to speak. If passed, Bill 30 sees a new prohibition on employers making false or misleading statements to the WSIB about a worker's claim. It also implements new administrative penalties for this conduct. And there's also a proposal to treat failure to pay premiums as an offense with the potential for administrative penalties. Now, turning to the next slide. Thank you. Another major change would be increased fines of up to $750,000 per conviction if an employer is found guilty of 2 or more counts in the same proceeding. And finally, decision makers would be able to weigh aggravating factors like prior convictions, multiple counts, or a history of noncompliance when setting and determining these penalties. Now, the good news for all of us here today is that these potential changes affecting Ontario have not yet come into effect. We, of course, will continue to monitor the Bill 30 as it proceeds through the legislature and provide updates, likely through our newsletter, as they come into effect. But as we've seen from prior versions of this initiative by the government, these changes are happening quite quickly. So do keep an eye. Now that we've gone through the proposed changes, I want to shift gears to recent and upcoming notable changes to the employment standards legislation, and in particular amendments to the Employment Standards Act. If you move on to the next slide, please. Thank you. So there's 2 things I want to talk about in this segment. The first is the new long-term illness leave, and the second is the new job posting requirements in Ontario. Now, both of these changes are particularly important for your HR professionals and managers to understand. I can tell you that many of my colleagues in Ontario are regularly filtering questions from clients with respect to these changes. That may include some of you that are on the call today. Both of these changes are designed to enhance worker protections and promote fairness, and both will require businesses to review and adjust their current policies. Now, given our time constraints today, I only have a few minutes to discuss each point. That said, we could probably do a whole 40-minute section on each of the new requirements. So turning first to the long-term illness leave. This actually came into effect. It's come into effect already, and that was on June 19th of 2025. So the new leave is a statutory entitlement. Obviously, it means it's going to apply regardless of what your workplace policies or benefits already offer to your employees. The key details are that employees with at least 13 weeks of service will have access to this new statutory leave. Eligible employees are entitled to take up to 27 weeks of long-term illness leave in each 52-week period. Now, in order to qualify for the leave, the employee has to be unable to work because of a serious medical condition, and they would need to provide a medical certificate from a qualified health practitioner. There's a bit of guidance on what the certificate would need to say. It's really no different than other sick leave notes. So it's, the employee has a serious medical condition in this case, and it would set up the length of time that the employee will not be working because of that condition. Now, this is clearly now one of the longest job protected leaves in Canada. On the one hand, this amendment sends a strong signal from government that workers' health and security are a priority. At the same time, it's really just putting into the ESA what already happens in practice, right? Employers granting unpaid time off when someone can't work for a medical reason. That said, it obviously goes a step further than the obligations employers owe under human rights legislation by setting out clear rules and rights in the ESA. So in terms of a takeaway, if you have not already done so, we would strongly recommend that you update policies so leaves of absence rules are included. Sorry, this new leave of absence is included in your policies. Check your benefits plans to ensure that evidence requirements don't conflict with ESA rules, and train your managers and your HR professionals to handle these requests consistently and avoid compliance risks. In summary, employees now have a clear statutory protection for absences due to serious illness, and your workplaces need to adjust if they haven't already done so. The shift now is from a case-by-case accommodation basis to a standardized ESA entitlement. So bear that in mind. Up next, if you could turn to the next slide. Thank you. So this is the amendment to the ESA regarding publicly advertised job postings. Now, the new job posting rules are geared towards fairness and transparency in hiring, and they will take effect on January 1 of 2026. The rules will apply to your workforce if you have 24 or more employees on the day the publicly advertised job posting is posted. As noted on the next slide. Thank you. So every publicly advertised job now has to include either a specific salary or a specific salary range. If a job pays over $200,000, there's actually an exception. You don't need to disclose that. However, if you do end up using a range, again, that would be below $200,000. If you use a range, as opposed to a specific salary, the range can't be more than $50,000 apart. If you use AI in your hiring practices, you do have to say so. You can't ask for Canadian work experience in the advertisement or on the application form. On top of that, you need to keep copies of all postings and related documentation for 3 years. And you have to let candidates know your hiring decision within 45 days of their last interview. So what can or should your organization do in advance of January 1st if you haven't already taken steps in light of these upcoming changes? The first is, Thank you. The first would be to review and update your publicly advertised job posting templates to include or remove the new posting requirements. Train your HR.
Hi there. Sorry, it seems that we've lost Genevieve's connection. So I think until she returns, we're just going to move on to what's happening in British Columbia. And then we'll circle back when Genevieve joins us again. So as Genevieve mentioned at the outset, my name is Matthew Ray. I'm a lawyer here in Miller Thomson's Vancouver office. And today we're going to talk about 3 major changes in BC. The first being Bill 11, and this is amendments made to the Employment Standards Act. And then we're going to shift into changes to the minimum wage in BC. And then finally end with Pay Transparency Act. So if we can shift to the next slide, please. So what's changing with Bill 11 and why? So this change is getting away from requiring sick notes or allowing employers to ask for sick notes for short-term absences for illness for employees. And the goal in doing this is, as stated by the government, is to free up more doctor hours. As we know, we have a healthcare crisis right now going on in BC. And so they estimate that this will alleviate or add about 180,000 hours a year to doctors' hours, or give that back to them, and also allow employees to recover and not worry about going to a doctor's office and getting a note. So that's the whole gist of why they're bringing it in. And so what the language right now is suggesting is it will make it unlawful to request a specified health record when an employee takes a health-related leave in specified circumstances on a short-term basis. So what we know right now is a specified health record is a note or a document that a health professional prepares at the employee's request to confirm the reason of the leave. And then the second portion, the health-related leave, means a leave that or absence from work related to health, illness, or injury. And then the third point there is a specified circumstance. These are circumstances which are going to be specified in future government regulations. They're not going to be set out in the amendment to the act. And so until these regulations come out and actually tell us what these specified circumstances are, it's probably going to be best practice that any illness or absence caused by illness of a few days could fall within the ban for these notes. So we should just plan for until we know what those specified circumstances are to treat them all as specified circumstances. And so then the consultation, right now there's supposed to be going ongoing consultation with public interest groups about how to implement these changes, what the changes are going to look like. It seems to be ongoing. There's not a lot of insight into that right now. But then when is this expected to come in? So the bill proposed that this was going to come in with influenza season in the fall in BC. We're now officially in fall. We still don't know when it's going to come in, so there's still a little bit of wait and see. From all indications, it's in the works, and they still intend to release it this fall. So when this change does come in, it's going to be important to monitor the changes. So when this comes out, we will be releasing a publication that will provide some more details on the rollout, the language, all of that. So please keep tuned. So we're going to go into so why this matters from our perspective as employers. So this is very important to keep in mind, the duty to accommodate. So this change may prove to be complicated or to complicate our obligations, as medical notes provide us with a opportunity to understand what needs to be accommodated. So we need to, in the short term, before the regulations are released, to ask ourselves, is this a type of leave that will trigger this ban under the act? And not just reach for the I need reasons why this leave is taking place. So that's just the thing that has to be in the forefront of our minds when these employees are going off. So we're going to move to next slide, please, there we go. So in the short term, what do we need to do? We need to sort of be mindful that this is coming down the pipe, sort of plan as best we can for these types of changes, and then be nimble when they do come in. There's going to be some growing pains, just like any implementation of new legislation. So at this time, it's sort of speculative what our advice on this is going to be until we actually know what the language in the amendment looks like and what the regulations set out. So best practices for this would be to update your HR providers, your maybe in-house HR people, to let them know that this is coming in. And the best practice at this point is to treat short-term illness leaves as being fitting the requirements of the act, that we're no longer able to ask for these medical notes. So yeah, basically keep your eyes peeled for this and publications from us on this, advising on how to deal with the amendments. So now we're going to move on to changes to minimum wage. So on February 18th of this year, the Employment Standards Regulation was amended by an order in council, and these amendments were put in place to increase the minimum wage for certain employees and implement automatic annual adjustments to the same. And so this change is based on the average change in BC of the all-in consumer price index, which is basically the official measure of inflation. So we're going to move on to the next slide. Okay. So when I said most employees, that's because there are exemptions carved out within uh, this regulation. So there are certain industries that are going to be pegged at a different rate. So this is support workers, live-in support workers, I should say, camp leaders, resident caretakers, and farm workers, and they'll be paid at a piece rate or paid pursuant to the minimum wage rate set out in the regulation. Um, and then for all other workers that aren't that's not a complete list, by the way. There are more exceptions. Um, but for all other workers on June 1st, their minimum wage went from 17.40 to 17.85 an hour. And this is going to be adjusted annually on June 1st. So what does this mean for our purposes? So this means that there's now some predictability. We know it's going to come in on June 1st, and we know it's going to be pegged to the CPI. So what can we be doing in the meantime? Next slide, please. So what we should be doing is reaching out to our payroll providers, updating them that this is going to be taking place June 1 of every year, and just make sure that we are planning appropriately. So now we're going to move on to the next slide. Sorry, onto the next slide if we can. There we go. So the Paid Transparency Act. There hasn't been a change to this act. What has changed, though, is the staggered rollout of this act. So for those of you who don't know, in 2023, this act came out. And what it was is it was an act to address systemic pay discrimination by requiring employers to disclose pay information in job postings and submit annual reports on a regular basis to provide the stats and figures of how pay was being distributed within their workforce. There was also a requirement that job postings must include the expected pay or pay range in all public job postings to promote transparency in the job market. On pay history, employers cannot ask job applicants about what they have been paid by other employers. And so, again, this helps to break the cycle of discrimination against women and gender diverse people. Employers may still use pay history information they have already have about an employee to determine pay for a new position, but they can't ask about prior. Employer reprisal. So this is to open or foster open discussions about compensation. So employers cannot dismiss, suspend, demote, discipline, or harass any employee who asks about their pay, reveals their pay to another employee or job applicant, or asks about their employer's pay transparency report. And so the last point on that is the pay transparency reports. So like I said, this was a staggered rollout. So if we can go to the next slide. So this is how it has been rolled out. So any provincially regulated employer above a certain size must complete a paid transparency report by November 1 of each year following a phased rollout. And you can see the rollout there. And so why this is a big change coming our way is because you see November 1st of this year, all employers with 300 employees in BC or more has to have these reports. And so in the following year, November 1 of 2026, all employers with 50 employees in BC or more now need to report. So that's quite the jump. That's going to capture a lot of employers. And so what we need to be doing in advance of that is starting to think about, okay, how do we put this report together? And luckily for us, if you go onto the government website, there's a template that they have you or that you can use, and there's like sort of a Q&A that you can walk through to see what has to be in this report. And for employers who are on the call today that have 50 employees or more, we need to start turning our minds to putting these reports together. And so that's the major takeaway. I want to leave enough time to go back to Genevieve to finish off her slides. So, any questions on this, you can address them to us. I understand in the agenda notes you'll have our contact information, or you can put questions into the chat that will be redirected to us. So, thank you. I'm going to turn it back over to Genevieve.
Thank you very much. And my apologies, everyone. That was not my intention to drop off like that, but here we are. So where we ended up is we were just reviewing really the practical takeaways for how to get your organization ready for the change coming on January 1. So I'm not sure which point I left off on, but first and foremost, you want to make sure that you review and update your publicly advertised job posting templates to include or remove the new posting requirements. Train your HR and your hiring teams on these new rules. You'll want to review compensation, internal pay practices as well. Excuse me. And you'll want to establish a clear process for communicating hiring decisions and retaining the required records. The bottom line is these rules are really pushing us towards greater transparency and inclusivity. Updating your hiring practices now will help keep your organization compliant and competitive in a tight talent market, because that's frankly what we're dealing with at this point. The very last comment I wanted to make, we can just jump to the next slide really briefly. This is just a reminder, a friendly one, that minimum wage increases next week. So you'll want to make sure that your payroll team or your HR folks are on top of that. That pretty well concludes my portion. And Matt, maybe back to you for a last minute recap.
Thanks, Genevieve. Yeah, so in closing for today, I know there's a lot to take in. We went over them on a pretty high level. If you have any questions at all, please reach out, and we'll be more than willing to answer any questions or clarify anything maybe that didn't make sense on its face. But yeah, we would also like to thank everybody for attending today, taking time out of their busy days to come to our presentation. I'd also like to thank Genevieve and Sophie for their presentations. And don't be strangers, reach out. We're here to help. So thank you all.
Thanks so much.
Thank you very much.